If you don't show up and the two of you have an uncontested divorce and all of the documents are signed, then the divorce will simply proceed without you. For a civil case, unless you are court ordered to appear, which it doesn't sound like you are when it's uncontested like this. When it's uncontested, only one party needs to show up. So you'll be fine, nothing will happen. You'll probably receive a copy of the documents either via email or via mail, depending on how they decide to handle it. New debts stop being something that you're charged with or that is part of the marital estate, usually the date of filing. So the court has the ability to make a best interest type of analysis, right? Whatever would do the parties justice when it comes to what date to value certain assets and liabilities. So usually the cutoff date is the date of filing or the date of separation, and it really depends on your facts. Also, that's how we argue it in court, whatever one is in your best interest and that the truth can follow. No, you're not responsible for his debts during separation if you can prove the date of separation and that he was spending money that was not related to the marriage. If the debt is for paying towards an asset, of course you'd be responsible for that. But if you guys are already separated and that can be proven, then that's something we would argue to the court to get that tidied up and that you are not responsible for. No, actually, this is a favorite bar question. The engagement ring is non-marital because it's a bargain for exchange, right? It's a contract. So for the contract, you say, will you promise to marry me? And she says yes, and she completes the process of marrying you. She's done everything and she's entitled to that ring and it's just hers. So if you think you want your ring to be something included in the marriage, you need to buy it during the term of marriage. So Florida is a no-fault divorce state. The only time that your dating life or if you had an affair will matter is in alimony. So if you think you might be entitled to alimony, my recommendation is probably not. But in most all other circumstances, I don't know, might help you get through the process of the divorce. If the house is in your name, but it was purchased during the pendency of the divorce, it's still something that's going to be a marital asset, even if he left. So his abandoning of the house is not likely to be something that will result in more money because he left. It'll be about yes, you can ask the court for that. Whether or not you'll get it is another question entirely, because you're not entitled to do it because sometimes that particular medical procedure can put the child in harm's way, and the court won't order that for sure. You can ask for it, but the most likely of outcomes is that it will happen once the child is born. And don't worry, they're all born one way or another. Yes, you can have him served in another state. And if you've been a resident in the state of Florida for 6 months or more, you can get your divorce here. You can speed up the process of yourself getting divorced by simply noticing it for trial. That's how we would get you as close to divorce as we possibly can. In our county and in most counties in Florida, they require you to go to mediation first. But once you've gone to mediation, notice it for trial and make it happen. Not during the pendency of a divorce. There's actually a prohibition on relocation for relocating more than 50 miles, and she could really be held in contempt of that. If you suspect that's happening, you should make sure you file something immediately. If it's before your divorce is pending, then you're going to have considerably more problems because she could move and you're going to have a lot of scrambling to do and to file on. She can take them before your divorce is filed. So if those are your facts, you should file your divorce as soon as possible, because if she can establish that she has moved there and her residence is there before the date of filing, you are kind of shit out of luck. And you're going to have a much tougher battle to fight to get those kids back from South Carolina. So this is the reason not to linger in a should we or shouldn't we get divorced state if you think you know you might get divorced. If your divorce is already started, he can't kick you out of the home. We could file something to stop him from doing that. There's a status quo order. As far as support, that's going to depend on the facts of your circumstances and if he has the ability to pay support. But in most counties, you'll have to go to mediation before we can get any temporary relief. So the answer to your question is no, he can't kick you out if you've already started the process of divorce. So if you're changing your name through the process of a divorce, you have to go back to your maiden name or a former name. So for example, if you were married 2 times, you could go back to your original maiden name. The court doesn't allow you to do what could be done in a name change petition, like if you wanted to pick another name entirely. So this is probably a question that should be had with an immigration attorney, because the status of your immigration isn't always affected by getting a divorce. People going through the immigration process get divorced all the time. I can and will be able to get you divorced, and in most instances, your immigration won't be stopped because of it. It's a bit bold of you to believe you'll get your divorce finalized before that interview, where it's likely, even though you filed, you won't get your divorce finalized before that very upcoming interview. But it is unlikely to stop you from being able to get your immigration completed. So this is probably a question that should be had with an immigration attorney, because the status of your immigration isn't always affected by getting a divorce. People going through the immigration process get divorced all the time. I can and will be able to get you divorced, and in most instances, your immigration won't be stopped because of it. It's a bit bold of you to believe you'll get your divorce finalized before that interview, where it's likely, even though you filed, you won't get your divorce finalized before that very upcoming interview. But it is unlikely to stop you from being able to get your immigration completed. Um, you got a lot going on. So firstly, you probably should make sure that you get a consultation to discuss each of these things. However, you will be entitled to whatever was acquired during the term of the marriage, and that is for both the marital assets and the marital liabilities. So you're liable for the credit card debt as much as you are entitled to the retirement funds acquired during the marriage. It's best if you can have him personally served. That's what the law requires. If you can't have him personally served, you will have to go through the publication process. But if you know where he is and you know how to contact him, your publication won't work. You'll have to have him personally served. Um, you got a lot going on. So, firstly, you probably should make sure that you get a consultation to discuss each of these things. However, you will be entitled to whatever was acquired during the term of the marriage, and that is for both the marital assets and the marital liabilities. So you're liable for the credit card debt as much as you are entitled to the retirement funds acquired during the marriage. We definitely will be able to get you divorced if you've been living in the state of Florida for 6 months or more. And just because you don't know how to get divorced, that's okay. There's plenty of things I don't know how to do. I have no idea how to change my oil. I could never get that done. So we'll handle that for you. If you're legally living in the United States, yes, you can be divorced here. No, when you get divorced, you do not have to go back to your name before you were married. You can, but it is actually the woman's choice, and the man cannot take his name back because he gave it to you. And I don't know, no takebacks. Um, yes, your children have to be included, and we have to address any children born during the term of the marriage. Children that were not born during the marriage and are not common to both of you do not have to be included. For example, if the two of you had a baby and got married later, then that child will have to be included because technically you ratified the legitimacy of that child. They then become legitimate if you're looking for some old-timey word. You can't, and that's part of the problem, is that you can't put a child in the UCCJEA because you need their date of birth and you need their legal name. So they won't be included in the UCCJEA affidavit, and you usually can't include them in the child support guidelines until they're born. However, the mother's pregnancy related expenses are recoverable. That's completely accurate. You only have to have irreconcilable differences, meaning the two of you can't agree that you want to stay married, right? So think of it a lot like consent. You have to consent to continue being married. Both parties have to consent to that, unlike in some other countries. And there's no separation requirement. So in Florida, it is not like Illinois, if you know, based on what you said. There's no date in which you need to be separated for. So if he kicked you out and you've been married for under 2 years like that, you're really going to have to make sure that you figure out a way to support yourself, because getting quickly into temporary matters is just not always incredibly practical in the state of Florida. And our alimony laws are not very favorable in short-term marriages. Yes, actually. And legally, the child that you gave birth to during the marriage is legally your husband's child. However, you'll have to go through a process of de-establishing paternity of your husband and establishing the paternity of your boyfriend to make sure that you can get a divorce and that your husband is not on the hook for this. Hopefully, your husband will be cooperative because that will make this process astronomically easier. You do not need to be separated for any period of time before you can get divorced in the state of Florida. I could get you divorced if the two of you are still living together. You do the best you can. File with what you know and what you think your expected expenses are, and estimate whatever you don't know for sure, or indicate on your financial affidavit what is paid for by your spouse, right? If your wife pays the mortgage, if your husband pays the taxes and you don't know exactly how much it is, just put either an estimate to what you think it is or unknown, right? So the important part about your financial affidavit is that you're honest on it. That totally doesn't matter. The court does not care about your sexual relations. And Florida's a no-fault divorce state. So if the status of your sexual relationships didn't result in a crime, it's not very good material for us to be presenting to the court, and I won't guide you through discussing it. So, fortunately for you, we will be able to get you divorced through a publication, and we just won't be able to deal with the custody issues quite as easily. But there is something that you could do, but it's going to depend on your facts, right? So it'd be easiest and best if we can get him served, but if we can't, that's really not a problem, and we'll figure it out. Well, good news, because even if one party doesn't want the divorce, the court will still grant a divorce. That is an irreconcilable difference. So the two of you will have to develop a parenting plan and a marital settlement agreement if the two of you come to an agreement, and if not, the court will do one for you. So there is no separation period like that's mandatory during the pendency of a case. So that's probably not exactly what you're thinking it is. And that 6 months time frame is not really relevant to anything except for perhaps some equitable distribution. Not usually. In most instances, it is a requirement that you need a parenting plan established, or at least the divorce process started, for there to be a court-ordered parenting plan. Now, you and your husband can sign a parenting plan and abide by it, but in order for it to be enforceable, you need a cause of action as a vehicle to drive that enforceability. So you can send the papers to your spouse via email, but it won't be deemed proper service. Proper service is with, in the state of Florida, is with a process server, or if they file a document that says acceptance of service. So they would need to file their acceptance of service, or they would need to be personally served by a process server in the state of Florida. And just as an aside, they can't be served on Sundays. So we actually have a really great way that we can handle this. We can get you divorced by publication if we truly cannot find them, and you have to make a diligent effort to search for him. So once we search for him and we find that we cannot find him, then at that point we can get you divorced. We won't be able to handle any of your time sharing, child support, or equitable distribution unless he's personally served, but we can get you divorced. It's really going to depend when it happened. If the two of you or he spent the money during the term of your intact marriage, probably not. It's America, and you are free to be an irresponsible person with your finances. If the two of you are not going through the process of a divorce and nothing is filed, there's really no recourse that you can go through to try to figure out whether or not how to get some money out of him, right? That's between husband and wife while the two of you are married. However, if the two of you are in the process of a divorce, then you will have to file for temporary support and seek out some type of money during the interim, right? During the case and while it's pending until you can get a final order. She's probably financially stable because of the marital relationship and your ability to provide for the family. So there is, like we had discussed in a previous video, a status quo order, meaning that you should maintain the status quo or what's financially been the normal responsibilities if you have the ability to do so. If you don't have the ability to do so, then you obviously can't do that. So, this is something you're going to have to make sure that you figure out and look at your finances and take a serious input into what support, if any, should be appropriate before a court order. Because if you know you're going to be on the hook for some child support or alimony, you look real good to the court if you take the initiative to go ahead and pay some voluntary support anyway. Yes. If you are a Florida resident for 6 months or more, you can get a divorce here. Since you said you don't have any property or any children, that's the easiest way for us to get you divorced. If you had property or children and she's never been a resident of Florida and she wasn't in the last 6 months, we couldn't deal with those issues, but we could get you divorced. I got you. She don't need to come here and she doesn't need to cooperate. Florida is electronic service. So if your spouse is willing to sign all of those documents and electronically serve them through the Florida e-filing portal and the two of you are in agreement with everything, yes, you can absolutely move forward in that way. You'll get divorced without needing service and without needing to go to court. We can actually file a motion if someone is excessively spending on the marital estate. It's waste and dissipation. So that's something that we could really address for you if he truly is spending through the money, and try to enjoin him or stop him from spending through all that money. So you would be entitled to half of the marital home if your name is not on the mortgage or the deed, if the home was purchased during the term of the marriage and with marital funds. So there are more instances than not that the title and who's on the mortgage doesn't matter and it's still marital. So in Florida, it's a no-fault divorce state. So it doesn't matter the reason you want a divorce, and the state of Florida will grant your divorce. So the salacious nature of him cheating is not something that will be litigated in court. You don't have to tell that story in court, and we can't force him to tell that story in court. It'll be objected to.